back here at home, major political developments overnight. California's Secretary of State confirming President Trump will be on their ballot for the state's GOP primary.
Yeah, this news came hours after Maine became the second state to remove the former president from its primary ballot. Our Tom Dempsey joins us with the latest. Tom, what do we know about this current situation with many of them citing the Constitution?
Hey, good morning, Nick. Yeah, though this morning we know former President Donald Trump's legal team will quickly file an appeal to this decision coming out of Maine, which became the second state to bar former President Trump from appearing on primary ballots. This further sets up a big showdown in the U.S. Supreme Court. Maine's Secretary of State issued this most recent decision, accusing the former president of spreading a false narrative of election fraud and inflaming supporters on January 6th. She went on and accused Mr. Trump of preventing the peaceful transition of power and remained aware of the likelihood of violence, but took no timely action to stop it. In her decision, the Maine Secretary of State writing, quote, "The events of January 6, 2021 were unprecedented and tragic. They were an attack not only upon the Capitol and government officials, but also an attack on the rule of law. The evidence here demonstrates that they occurred at the behest of and with the knowledge and support of the outgoing president." The Trump legal team, of course, quickly responded, quote, "Make no mistake, these partisan election interference efforts are a hostile assault on American democracy." These legal challenges, though, all revolve around Section 3 of the 14th Amendment, barring insurrectionists from holding office. The section got put in place around the Civil War in 1868 and was meant to keep former Confederates from gaining power. The cases in Colorado and Maine are just two of many involving the 14th Amendment, and whether or not Mr. Trump's involvement on January 6 can be considered taking part in what's being called by Colorado and Maine as an insurrection. According to the Lawfare nonprofit group, 12 states have pending cases and one has a pending appeal. While Colorado and Maine disqualified the former president from appearing on state primary ballots, 5 states, including Florida and New Hampshire, dismissed similar lawsuits. The Colorado Republican Party has already asked the Supreme Court to review the case out of Colorado, which again sets up this very big showdown in the Supreme Court, because depending on how the justices side in that, the decision in the Colorado case could impact those other cases being heard all around the country. Guys?
Yeah, I tell you what, it's been fascinating to watch how each of these states has responded so differently, interpreted this insurrection clause so differently, and where we move forward from here. Tom Dempsey, thanks so much. For more on this, let's bring in Mercedes Colwin. She's a trial attorney and legal analyst. Mercedes, always good to have you on. Can we just start off with what seems to be, I think, a big question on everybody's minds right now, and that is timing. What do you make of the timing of these cases? I mean, why are they just now ripe 3 years after January 6th?
That is such a great question, Markey. Frankly, it might just be because we're entering into the final stages, which will be the primary this summer. So that's why it's vital that these types of issues are determined, because one, the ballots, especially one in Colorado, the ballot has to be finalized this month in January of 2024. So it's vital that all the individuals that are on that ballot are fit for to be voted upon. And that's one of the arguments that the Colorado electors said, is this timing is not political, rather. It's because our ballot, there is a specific time which the ballot has to be finalized. That's why the inquiry is starting now.
Yeah, a lot of people disagreeing with Colorado that this is not a political move here. Let's talk specifically about the constitutional clause at issue here, which, of course, you know, it's Section 3 of the 14th Amendment, and it states this: no person shall be a senator or representative in Congress or elector a president and vice president or hold any office, civil or military, under the United States, who, having previously taken oath as an officer of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. I know that's a lot, but only fair to read that off this morning so everybody knows what we're talking about. Many seem to be arguing we should not apply this to President Trump because it's just too partisan, it's too divisive. But Mercedes, what's the legal constitutional argument that this does not apply to him?
Well, Markey, I'm so glad that you raised the actual language of the statute. It seems pretty clear that any office, if you are a participant of a rebellion or insurrection, you are not qualified to sit for office. So I'm not entirely certain why there are these intellectuals out there who are saying that somehow this doesn't apply to the president's position. Of course it does. I mean, if you look at the highest position in office, conceivable, it is the president's position. And if it can apply to the lower types of elections in terms of a senator or a congressman, how could it not possibly apply to the president? So it really is the language of the statute. It seems pretty clear. The one question is whether or not the U.S. Supreme Court will take this case up, because obviously you have to seek permission for the U.S. Supreme Court to look at this case to begin with. Two, there's no historical precedent on it. This would be the first time an individual seeking presidency or looking to, or actually being disqualified on the basis of this section. But if you just look at the letter of the law and how it can be interpreted, it could easily apply to the president.
Yeah, and let's just assume this case is taken up by the U.S. Supreme Court, which it most certainly will be eventually. This court is headed by a conservative majority that really advocates originalism when interpreting the Constitution, such as, with the Second Amendment, most notably. Could Trump's candidacy survive a consistent originalist reading of this clause based on the facts of January 6th? What are you expecting from the highest court?
That's such a great question, Markey. Frankly, that is exactly what will happen. If we are talking about those who are the originalists and look at the letter of the law as it is written, it's not about how it can be applied, but what was the interpretation at the time. And as we just mentioned before, if you are applying it to lower elections, that these other elections that are actually specific and that are identified there, how could it not be applied to the president? It doesn't seem likely that if these originalists look at this particular statute, that they will conclude that the president can move forward on these ballots.
Yeah, when you mentioned, when it was written at the time, what we would give for our founding fathers to be here right now and really tell us what they meant when they were writing this amendment in the Constitution. As always, Mercedes Colwin, thanks for your time and your insights this morning. Appreciate it.
Well, my pleasure. Thanks for having me.